Okay, so good afternoon, everyone. It is 1 o'clock. We are gonna start. There's still a few more people that are supposed to come in, but we'll get started just in the interest of everyone's time. So today's module is the health and safety module. It is something that is one of the 5 core components of your CPC exam. It is a little different than some of the other courses you've probably taken so far. It'll probably be approximately 2.5 hours long. We'll take a break halfway through, a 5-minute break just to get up and stretch, go to the washroom, pour coffee. And the reason I say it's a little different, it's a little heavy with information. Health and safety is a big topic. It is something that is related to legislation and law, and we're going to get into all of that. But the core focus is going to be making sure that we cover the topics you're going to need to pass your CPC exam and making sure that you are successful in doing so. So my name is David Wells. I've been involved with health and safety at a national level in staffing for about 18 years, 19 years. And one of the benefits of the CPC program, as I see it, I'm just going to stop my video just to focus on the presentation. So if anyone has any comments or anything else throughout the meeting at all, just record them in the chat function, please. So I'm not going to go through this. I'm sure you've seen this already, obtaining your CPC certification. The mission statement, again, because this is your last module, I don't believe we have to go through this per se. You've probably already gone through this 4 times, but it is an important sort of thing in terms of as members of ACSESS. And as I was saying earlier, one of the benefits of the CPC program is you're learning from people that are generally involved in the industry or were involved in the industry. You're learning some really relevant content for the industry that you work in. And to me, especially when you're speaking about health and safety, every health and safety course that I've taken outside of ACSESS has been really focused on other sorts of industries, other sorts of environments. And a lot of times I left scratching my head, okay, how does this apply to our industry? And my focus today is going to be on that, to go through the same sort of content that we'd normally go through, but ensuring that we have the core focus of looking at it from the temporary employment industry. And we have a couple learning objectives today. As I said, the number 1 objective today, this isn't going to be a full-on course on health and safety. You can do it for years. There's always legislation changing. It is a big topic to cover, especially in 2.5 to 3 hours. We're going to try our best, though. Some of the things we're going to be covering will be related to legislation. Some of it does have a little bit of a slant to Ontario, so I know that there are a few people from other provinces. I'll kind of address that where I can, just so that we're not, you're not going back and saying, oh, it's supposed to be 7 days and I was told 3 days in this course. I'll try to highlight those at every instance that we can. And we're going to be taking a look at a number of topics. We're going to be looking at safety principles and risk management. We're going to be looking at the legislation that applies to health and safety, rights and responsibilities of managers, supervisors, and workers. We're going to be looking at hazard recognition and control measures. We're going to be looking at workplace inspections, accident investigations, developing and implementing effective workplace programs. And the focus after this course is, there's a number of goals to achieve. The first goal is not to know occupational health and safety legislation. An important goal to know after the fact is, if something happens in your workplace, you'll have a better understanding of, okay, this may be a workers' compensation issue. This might be an issue where we have to report to the Ministry of Labor. It may be related to some other health and safety type of legislation. You're definitely going to know your health and safety responsibilities after today's course. Determining ways of meeting your occupational health and safety responsibilities for temporary employment agencies. You're going to be able to identify hazards and develop safe work practices, take leadership in developing and implementing an occupational health and safety program, and understanding some of the consequences of non-compliance. We'll go through a few instances of that, but occupational health and safety is truly something that when it does go wrong, someone typically is either being injured, whether minor or more serious, or you have some sort of environmental concern, or if it is major, you might have some sort of machinery concern, a broken machinery, an accident, something of that nature. So those are the goals of today. We're going to start with the Occupational Health and Safety Act. And again, this is a huge act. It's constantly changing. It's constantly being added to. So the goal today is just give a nice primer, something that will assist you in your day-to-day life. And one of the things that does happen in this module is there's going to be a few case studies that I'm going to refer to, and this is going to be the first case study. And when we do a case study, I'm gonna read it to you, read an overview, and ask a couple questions. I do ask that you respond in the chat function, just so that we can have a group discussion and kind of learn from each other. So in this case, the case study today is from Saskatchewan, 2015. And it talks about an 18-year-old worker who had been on the job for 6 or 7 hours, and they fell at least 20 feet and broke his wrist and 2 vertebrae. He'd been working on roof trusses that were 20 to 25 feet off the ground. He had not received any training, and there was no fall protection equipment provided. The customer tried to blame the worker's fall on his untied boots. I'm going to ask you, please quickly respond. Would you have considered this client, and what would you have done differently? If you're supplying labor to this client, which is clearly some sort of roofing type company, would you have supplied to this company? And how would you have done this differently? So please take a minute, go ahead and work through the chat function, and we'll go through them. Okay, so we do have a couple responses in the chat. So thank you everyone for doing that. And one of the first thing is, and this is a great first comment, is we do a workplace inspection on this client. And whoever answered that, I think it was Andrew. That is a great answer. And the reason I say that, Andrew, is because it truly shows something that is tantamount to our industry. We are third-party suppliers of labor. And in order to do that, we need to be effective in understanding what our clients need, but also the work environment of the clients. So absolutely, had you done a workplace inspection, you probably would have saw that these workers weren't properly tied off, weren't trained. You would have noticed that right away. Another answer we got, I would have ensured working at heights was a requirement first for employees. Absolutely. Every province has some sort of regulation regarding working at heights. Generally, any work over 10 feet requires specialized training, as well as equipment and company processes and procedures. And so I think those two, the other answers kind of encapsulate the same sort of thing. Those two answers are great in this case. Working at heights is something that is definitely required, and that should have been the number one thing had we known we were supplying labor to a work site that's working on roofs. We would have taken a look at the previous training, the previous experience of the person. And one of the biggest caveats here is the phrase 18-year-old worker. And here in Ontario, we have what's typically always called, it starts around May, we have young worker awareness, and the Ministry of Labor will come to work sites that tend to employ young workers. They've typically included temporary employment agencies in those blitzes. And the reason being, during the summer, a lot of students let out and they come to the temporary employment industry for summertime work. And generally, anytime you're looking at young workers, they're not going to have the same sort of experience on the job as someone that has more experience, someone that has 10 years experience. As well as their age sometimes precludes them from, really kind of saying no to work that they aren't qualified to do. Not to say this in a roundabout way, but someone that's been working for 15 years and they're 35, 40 years old, they will probably be more inclined to say, you know what, I'm not trained to do this. It's 20, 25 feet up in the air. I'm going to exercise my right to refuse unsafe work. And we'll kind of get into that, but I think ultimately this was a great first step off for the course today. And I mean, ultimately, I think anyone in the industry would probably take a look at this order and, look at the risk versus reward of the order and really find out that, okay, this is a very serious injury. Someone broke their wrist, they broke 2 vertebrae, and they're 18 years old. They're probably, it's potentially a life impacting sort of injury. And that's definitely not a client, especially at the end of the course today, that we would want to take a look at without taking some necessary precautions. The Occupational Health and Safety Act and regulations. This is legislation within Canada that outlines the general rights and responsibilities of the employer, the supervisor, and the worker. And it contains information on WHMIS, critical injury, designated substances, industrial establishments, and first aid. And typically the way I always look at it, regulations kind of support the Occupational Health and Safety Act. So you're going to have certain sectors that are going to have more information related specific to their industry. And that's usually what regulations kind of how they interplay with legislation. Here in Ontario, we have 14 different, or in Canada, sorry, we have 14 different jurisdictions, 1, the federal jurisdiction, 10 provincial, and 3 territorial, and each has their own occupational health and safety legislation. So any of you that are working for multi-provincial companies, you're working across Canada, you're going to have clients where it intersects all these, potentially all these different areas. You're going to be involved in different provinces, and you're going to be required to know, or at least action in the different pieces of legislation within the provinces. And the one that is a little more uncommon is the notion of federal legislation. And federal legislation means companies that are federally regulated. So it's a little bit different than a provincial regulated company. Usually it involves some sort of action that occurs over provincial boundaries. Some examples are airports, banks, oil and gas, ferries, tunnels, radio and television, cable systems, banks, pipelines, railways, shipping and receiving services, telephone and radio services. And it's a little easier to think about if something is crossing provincial boundaries. There's a fair chance that it is federally regulated. And why that applies to us is if you're supplying labor, if you're supplying temporary employees to one of your customers who is federally regulated, you have to be aware of those differences. So your customer is going to be operating differently than what you're generally aware of if, let's say, you were based out of Ontario. They're going to have different rules, different regulations. They're going to have different holidays. And it's truly important to understand, if you are dealing with a federally regulated company, that you understand those differences and how to manage them for your temporary employees. It might mean your training is different. It might mean some of your paperwork is different. But it is, again, one thing that you want to definitely, if this occurs, you want to red flag that and say, okay, what do we need to know to deal with this company as a federally regulated company? OSHA aims to do a few different things. So these overarching sort of pillars of knowledge about it. One, to ensure employees' health and safety and well-being in the workplace. That's number one thing. You got to make sure everyone's going home at the end of each day. It's to encourage employees participating and maintaining improving health and safety, to involve employees to representation on committees, joint health and safety committees, which we'll get into, to help prevent risks to health and safety in the workplace, and ensure expert advice and resources are available. Your role as an employee within the system is to participate in health and safety meetings, onboard and train contract and temporary employees under their OSHA regulations and legislation, maintain and improve existing training opportunities, and ensure that on-site health and safety inspection reviews are done on a regular basis. So this is kind of looking at it from an employer perspective, as well as you as representative of your prospective employer. We have a multiple choice question, so please, I'm going to read it if you can answer in the chat function. So I complete a workplace safety site inspection. Everyone calls them something different: a risk analysis, a client site inspection, a risk assessment. Each one of our companies probably has something similar, especially if you've been involved with ACSESS for a while. But I complete a workplace safety and site inspection with every new customer prior to sending an employee out to work on the assignment. A, all the time; B, about 90% of the time; C, half the time. When I can get out to do them with customer sites; D, usually after they start working, I'll book time to go on site; or E, none of the time, as my employee tells me whether it's safe or not. So please take a moment, record in the chat function what you think the most appropriate answer is. Okay, so it's resounding A is the choice picked by everyone. So all the time with no exceptions. That's a great goal. 100%. That is what the expectation or the advice ACSESS would give to any one of our member clients. We want to, it is something that ACSESS has been promoting since I've been involved with ACSESS, and again, this is 15 plus years, doing a site inspection with your client. And we'll kind of get into that a little bit in greater detail later. But this question just was more to see, okay, so what kind of practices do the people on the call today have? So it looks like everyone is kind of in the same headspace. We try to do the health and safety inspections all the time with no exceptions. So that's perfect. So who is responsible for what? As I began the module today, our industry is slightly different. We're supplying third-party labor to our customers. So essentially, we have 4 parties through our contractual obligations that are involved with supplying labor to our clients. We have workers, customers, we have the supervisor, and then we have the staffing industry themselves. So when it does come to health and safety, the responsibility is something that anytime you have this many people involved, you're going to want to be really careful about ensuring the health and safety of workers, ensuring that everyone plays a key role in maintaining a safe work environment through training, education, awareness, and that everyone is on the same page with regards to the knowledge and skills and training of the employee themselves. And the best way to do this would be to make sure in your business contracts, you spell out exactly what sort of things you as a temporary employment agency are responsible for and what the client is responsible for. And the best example of this is WHMIS. Obviously, all of our companies probably do something kind of similar. We have a WHMIS program. We train workers on WHMIS, and we show video where we do the pictograms and we have some sort of presentation to do the WHMIS. But then there's also responsibility of the clients themselves to train on the specifics of WHMIS in their workplace. So it's pretty impossible for temporary employment agency companies to be knowledgeable on all the different chemicals that their clients use. So there is a duality of responsibility here between the temporary employment agency and the customer. And then to kind of layer on top of that, the workers and the supervisor will have additional layers of responsibility. So we do have this, we do have this point where everyone is responsible for the same sort of thing in the middle, but we do have to be very conscious of who is doing what. We have another multiple choice. And this one might be an easy one, I think. Who advises workers of hazards in the workplace and their specific role and provides written instruction where prescribed? Is it A, the customer, B, the worker, C, the staffing agency, or D, the supervisor? Please go ahead and record your answers, and we'll discuss. So is it the customer, the worker, the staffing agency, or the supervisor? Maybe I jinxed it by saying this was an easy question. Okay, we have some A's, We have some C's, and we have a couple D's. So in this question, the supervisor would be directly responsible for doing this. The supervisor is the person who's going to advise the worker of hazards in the workplace, what they need to do, and provides the instruction where prescribed. And maybe it's a bit of a trick question because the supervisor can be at the client level. The supervisor can be at the temporary employment, the agency level themselves. Anyone assigning sort of roles to employees, providing the training, dispatching them, they could be viewed as supervisors if a Ministry of Labor inspector comes in. And that's really important for us to understand within our own companies in that, whatever your person that does this, whether it's a recruiter or a staffing person or a staffing order, whatever it is your company calls them, under occupational health and safety, they could be viewed as a supervisor in this type of arrangement. So you want to make sure that your people within your offices are trained, and obviously all of you are taking the step to be trained by doing the CPC program, but you really want to make sure that you understand that sort of duality of where the supervisor may lie. What are the responsibilities of our customers? Our customers are in control of the work site. So they're going to have some very specific responsibilities with respect to the equipment, the materials, and the protective devices, and the maintenance of them, that they're provided, that they're available, and that they're used as prescribed in the workplace. There has to be a copy of OSHA in the OSA posted in the workplace. They have to make sure that information, instruction, and supervision is provided to all the workers. They must assign a competent person when selecting a supervisor. Customer must have in place a written, annually reviewed health and safety program, have it posted and implemented in the workplace program. Customer has to take every precaution reasonable in all circumstances for the protection of workers. And number 6, you're going to become familiar with that by the end of the day. Taking every precaution reasonable in all circumstances for the protection of workers. This is a term or a theme of thought that's going to be shared in a lot of different areas today. And it's by design. The Occupational Health and Safety Act does this. It's a little vague what this means, but what it does mean is making sure that you're being responsible, respectable employer rather, sorry, in these arrangements. So you want to make sure you're considering any special training provided by the customer in any form or agreement of reciprocating exchange of training. So what do I mean by that? If you're doing specific training, you want to make sure that you have the training records for your customer, just in case the customer, again, does have some sort of accident or incident, or they have a workplace inspection, or their joint health and safety committee is doing an inspection. You want to make sure that those training records, maybe not necessarily provided directly to the customer, but that you do have access to them. And the flip side of that, if the customer is providing specific training to your employees, let's say it is some sort of forklift training, if they are licensing the forklift drivers to perform the forklift functions, or they're doing fall arrest, or they're really doing anything, you want to make sure that you're getting copies of that training, so that in the case that something does happen, there's accident or incident, you have copies of that to show to the authorities at that time. And I mean, what happens in an accident? Communication is key, but contracts are better. And it's kind of what I was referring to earlier. You want to make sure that your commercial contracts are specifying who's doing the training. You don't want to be in a situation where there is a major accident or injury. People aren't going to be as nice at that point. They're not going to be as forthcoming with information, when they are potentially going to be charged. You do want to make sure that your contracts specify who is responsible. What are the responsibilities of the Joint Health and Safety Committee? They have very specific roles. They're designed to increase the safety within the workplaces. So they're looking at hazards. They're identifying hazards in the workplace. They're participating in programs to protect health and safety. They're getting involved with employee complaints, suggestions concerning safety and health. They take a look at injury and work hazard records, monitor, follow up on hazard reports and recommended action, participate in health and safety inquiries and investigations, participate in resolving workplace refusals, make recommendations to management for incident prevention and safety program activities, and monitor effectiveness of safety programs and procedures. There's a lot of responsibilities to a joint health and safety committee. And the reason being is the government views this committee as being integral to the safety and health of an employer's work environment. Many times, or most times, or all the time, it's the employees that are on the shop floor. They're going to see more things. They're going to be involved in the actual workplace themselves, whether it's a manufacturing environment or an office environment, whatever it is, they're going to be the ones probably seeing more things that are happening on the work site floor. So the idea is the responsibilities of Joint Health and Safety Committee are large, but their reach is large. Their ability to help make the safety of the workplace is typically pretty expansive. What are the responsibilities of the workplace supervisor? The supervisor needs to ensure that workers abide by the act. So they are the police people to ensure that the act is being followed and that the regulations and that they're wearing the prescribed PPE equipment or clothing. The supervisor advises workers of hazards in the workplace and their role and provides written instruction where is required. And the supervisor takes every precaution reasonable in the circumstances for the protection of the worker. Again, I referred to this earlier. This is probably the #1 charge, at least in Ontario, with people that have an infraction with the Occupational Health and Safety Act. It's that the inspectors will typically charge for the employer didn't take every precaution reasonable. Lastly, what are the responsibilities of the agency? So us actually working in the field, what are our responsibility? Very similar to the customers, actually. We've got to provide training. We've got to make sure that they're trained under OSHA and Provincial Compensation Acts. We've got to ensure that PPE is being worn, provided, maintained. We're going to ensure that workers abide by the act and regulations and wears the prescribed PPE equipment or clothing. And a copy of OSHA must be posted in the workplace. So you want to make sure that the Occupational Health and Safety Act doesn't view our industry any different. We still have the exact same requirements as customers because we are viewed as the employer of record. So as the employer of record, we do have a duality of responsibility with our clients to ensure the safety of our people. So it is a little more onerous in terms of health and safety and ensuring that your program within your company is representative of that duality of responsibilities. You need to kind of go over and above what a smaller type manufacturer, let's say, is required to do because of that duality of responsibility. So just bear that in mind. What are the rights of workers? So there's some basic rights of workers that are shared across Canada. And there's one note about Alberta, they just kind of, Alberta phrases a little bit different, and we'll get into that at the end of the presentation. But every worker within Canada, regardless of territory, federal, or provincial, we have these 3 basic rights. It doesn't matter if the person's full-time, temporary, or a contractor. They have the right to be informed of known or foreseeable hazards in the workplace. What I was saying earlier about information, instruction, training, and supervision, it's required to protect all those workers. And the Occupational Health and Safety Act doesn't actually define workers the same way as you might consider as the Employment Standards Act or what have you. They basically view anyone on the workplace floor as being a worker. So one of the questions that just came out about who decides whether it's unsafe. I'm not sure where that applies to, but we actually have a full section on that in particular, whether something's unsafe and what to do. And we'll get into that in closer to the end of the module, but we'll definitely get into that, okay? So I'm not ignoring your question, I'm just saying we have a few slides that we'll go through that later, okay? What are these 3 basic rights? What do they mean? The right to know is you have a right to know what hazards are present in the workplace. And you have the responsibility or the ability to be given the information, training, and supervision you need to protect yourself. You need to know what exactly the hazards are in the workplace so that you can make an informed decision, especially in our industry where people are being supplied to different companies. An example I always give is peanut allergies. So if you're sending people to work in a food production area at any of your clients and they work with peanuts, as a good matter of action, as a responsibility under the Occupational Health and Safety Act, you need to be notifying anyone you supply there that they are going to be working with peanuts. And that applies to everything. It's just the easiest example I always have. The second right is the right to participate. And what this means is you have a right to participate in keeping your workplace health and safety, which may include selecting or being a health and safety representative or committee member. You also have a right to report unsafe conditions and practices. You actually have a fundamental legal requirement to report unsafe actions. If you're working with a ladder and one of the rungs is broken and you're using it and you notice the rung is broken, you can't just put that ladder back. You could potentially be charged by the Occupational Health and Safety Act for failing to report that hazard. And lastly, the right to refuse. So you can refuse work that you believe to be dangerous to yourself or to your coworkers. When you exercise your right to refuse, you must follow the proper procedure. So again, I think this comes back to Andrew's question about who decides whether it's unsafe. We do have a few slides on this. We'll get into the right to refuse, but this is a fundamental right. It's a right to say, look, I don't think this work is safe. I think I'm going to injure myself, or I think one of my coworkers are going to injure themselves. And I have the right to say, no, I don't want to do that. I want this hazard looked at. And you know, the initial thoughts some people might have is, oh, people are going to abuse that. But this has been a fundamental right for decades and decades and decades. It is something that is looked at seriously by all companies because there is a legal requirement to provide this right to your workers. We have another question. So we're going to take, again, I'm going to read it. Please answer in the chat function. When should you do a site-specific hazard safety assessment at a new customer site? Do you do it prior to the assignment starting? Do you do it within the first 48 hours of the assignment starting? Do you do it prior to the assignment starting, or if new hazards have been introduced to a work site prior to the assignment starting and repeated when conditions at the work site changes? C, A, C, and D. So please go ahead, record your answers. So when do you do a site inspection, a client inspection, whatever it is you personally call it at your company? When do you do that? Well, so far every answer has been F. So we have a very smart group today. I agree with you. The answer is F. You want to be doing it before the assignment starts, especially if it's a new customer. You want to be doing it if new hazards are introduced or prior to assignment starting and repeated when conditions at the worksite changes. And by that, I mean if they introduce new, let's say, equipment that your employees are going to be using, if you are all of a sudden working in a different area of the plant or manufacturer place that you weren't previously looking at, if you've never seen that area, you want to be going and taking a look at it, making sure it's safe for your employees, and making sure that, you know, as a customer, you want to deal with that customer. And we'll kind of get into workers' compensation a little bit later and what happens when there is an injury, but there is a cost to doing business with quote unquote bad customers or unsafe customers. And it's not something that you truly want to make as a business decision. And one of the easiest things, the safest way to explain a client inspection that I've been saying for a number of years now in my own company is when you're doing a client inspection, ask yourself this one question. And the question is, would you send your partner, your child, your mother, father, your brother, sister, would you send them to work at this work site? And if the answer is a resounding no, because it's unsafe, it looks like someone's going to get injured, you may want to ask yourself if you want to do business with that particular client. And again, for the reasons I was just saying about workers' comp costs and you know, some of the conversations we had earlier about if you are charged under the Occupational Health and Safety Act, You don't want to be dealing with customers that are going to produce unsafe results, working at customers that are going to produce injuries. It's just going to drive up your costs and again, potentially get you fined or charged under the Occupational Health and Safety Act. We're going to switch gears for a little bit. So that's, we kind of got through the legislation. We're going to get very specific about the legislation and discuss the global harmonized system, what's effectively known in Canada as WHMIS 2015. And this is a big topic. We're going to cover it at a 10,000 foot level and kind of get into, okay, what do we need to do as a temporary employment agency to handle our education requirements for WHMIS? So what do you need to know? We're going to be looking at the history of WHMIS. We're going to be looking at some product classification, hazard identification, symbols, labeling requirements, safety data sheets, exposure to hazardous materials, provincial and federal regulation, and workers' rights. What we're going to be looking at is WHMIS as it applies to all Canadian workplaces and throughout the world. WHMIS is something that compliance is critical. It's something where someone can be injured very quickly without really trying to, through no fault of their own. If they don't have the necessary training, the necessary education and skills to deal with a chemical, or if they're exposed to a chemical on the workplace and they're not aware of its presence and not wearing the necessary PPE or not dealing with it appropriately, the margin for someone getting injured can be very high depending on the substance they're dealing with. And the history of WHMIS, it seems long ago, but it's probably not that long ago. We're looking at from the late 70s. In the late 70s, the Workplace Hazardous Materials Information System, the federal, provincial, and territorial governments began a process. They were taking a look at, okay, how do we deal with chemicals in the workplace? And they, as governments do, they formed a committee and they brought in government agents and they brought in employers and they brought in unions. And they started to look at this. Okay, people are getting injured from chemicals. What do we do about it? Fast forward to November 1979, there was the Mississauga train derailment. Some of you may have learned about this in school. Some of you may have been around when this was something that happened. But essentially what it was in Mississauga, which isn't as big as it was, or as big as it is now, still a big city at the time. They had an explosion and release of toxic gas that caused the evacuation of 200,000 people. And essentially what that was an environmental disaster. And as humans are, whenever there's a big catastrophe, we sharpen our pencil and we start to look at it, okay, how do we prevent this from ever happening again? And as we go through, we see in 1980, introduction of dangerous goods. In 1981, the government formed another committee to look at the feasibility of labeling hazardous workplace substances. And the good part of this was the committees involved. They involved the unions, they involved the employers, the employees, and the government. And they really started to take a look at it. 1980, they published the WHMIS report of the Project Steering Committee from the first committee. And then as we go on, 1988 was the execution of WHMIS on a national level. And what this really looked at was making it a national sort of program that was consistent across all the provinces, off territories, so that when we did train on it, whether you worked in Ontario or you worked in BC, you were dealing with the same sort of program. And then in 2018 was the timeline to complete WHMIS 2015. So basically in the early 2010s, they started looking at what I'm going to refer to from here on in as the global harmonized system that made this, instead of just a Canadian program, made it into a worldwide program. The lots to unpack there, the history of WHMIS, again, we've been dealing with it for a while, but it is based on the seriousness of it. It is something that is important. So the global harmonized system will help facilitate trade by eliminating multiple classification systems and enhance protection of human health by using standard and consistent messaging. What does this mean? As I was referring to earlier, this is a global system. It's a global process and procedure. And, we're very aware of the global supply chain at this point. Going through the past couple of years, we've seen where little kinks in the supply chain and the logistics of someplace have really impacted, the ability of us to secure things. We're living in we call it a global village, or, the world isn't as big as it used to be, just based on planes and trains and, our ability to share information. So what this is an example of is this was a real product, and they had different classifications for it. So in Canada, the US, and Japan, Korea, this product was labeled as toxic. In the EU, Australia, Malaysia, and Thailand, this exact same product was labeled as harmful. China labeled it as moderately toxic. New Zealand labeled it as hazardous. And India said this exact same product that was toxic in Canada, US, and Japan was non-toxic. So you can see what the problem could be here. Depending on where I'm buying this product from, if I buy it from Canada, I'm made aware that this product is toxic. If I buy this exact same product, chemically, functionally, everything else is the exact same. Had I bought this in India, it would have been viewed as non-toxic. So the chemical is not changing, it's the classification. So the government's, safety people across the world took a look at this and said, we got a real problem, we have to deal with this. And there are 5 basic areas of change. I'm not going to go too much into details just because we have been dealing with WHMIS 2015 for 7 years now. But they introduced new classifications. They classified physical products in the same instances. So again, kind of making the whole world look at products in the same light, and exemptions, hazard communication. And it was really something that, it took a long time, actually. It took a long time to coordinate the world, as you can imagine. But we're really going to see positive change, I think. And I'll show you kind of what I mean by this as we go forward. One of the biggest changes, anyone that's been doing health and safety for a while, if you've been involved in, any sort of training in health and safety pre-WHMIS 2015, you would have saw different sort of hazard symbols. What they did was, again, they standardized it. They call them pictograms now. And it's, pretty immediately recognizable. It's, a square on its point or a diamond on its point. It's typically red. And inside the border is a symbol that represents the potential hazard: fire, health hazard, corrosive. And together, the symbol and the border are referred to as a pictogram. And pictograms are assigned to specific hazard classes or categories. So what we have here is a little chart that shows exactly what the pictograms that are functional in Canada. So Canada has agreed on, we're going to make sure any product we produce here uses these pictograms. The exploding bomb, the flame over circle for oxidizing hazards, the gas cylinder for gases under pressure, corrosion for corrosive damage to metals, as well as skin and eyes, skull and crossbones, health hazard, exclamation point, and environmental. And the good thing about the pictograms at this point is they're very recognizable. They've really dialed in what the pictures are, so you can kind of see, okay, I know what the flame looks like, or I know what the corrosion sort of thing looks like. It almost doesn't matter what language is your first official language. You can take a look at these pictograms and very quickly kind of understand, okay, there's a skull and crossbones on this. I might want to be a little cautious, or I might want to go ask for some training, or I might want to go see my supervisor in how to deal with this. That was actually a good thing. The pictograms at this point now, they're going to be the same, hopefully across the world. I mean, every country, I think, involved in world trade has adopted this sort of program, or they're in the mix of the topic. And within the changes to WHMIS 2015, we had 2 sort of introductions of the hazard groups. We have the physical hazard groups based on the physical or chemical properties of the product, such as flammability, reactivity, or corrosivity to metals. So this is saying, like, what's the issue? Secondary, we have, okay, what's the actual health effect on the human? It's based on the ability of the product to cause some sort of health effect. It could be eye irritation, respiratory issues, asthma symptoms, breathing irregularities, or if they will cause cancer. And these are big level sort of hazard groups where you can lump things into very specific sort of statements. And these are called your hazard classes. Hazard class is a way of grouping together the products that have similar properties. Most of the hazard classes are common to the GHS, will be used worldwide by all countries that have adopted GHS. Some hazard classes are specific to WHOIS 2015. And it's very, again, they're high level, they're grouping items in these sort of bucket lists. So is it acute toxicity? Flammable gas, it's acute toxicity. Those are two of the big bucket classes for this. I'm going to ask a question. Please record in the answer box. Labeling. So is labeling materials is a way health hazard information is made available to users. And although it is not required by law, it is recommended that all hazard materials be labeled. So is that true or false? Do materials have to be labeled? And although it is not required by law. So this is a bit of a tricky question. Make sure you read it. This is one of those questions that if you read it twice, you may get a different answer. Okay, so everyone that answered, thank you, have answered false. And the reason being is this little line is not required by law. So labels are required by women's laws. I'm going to show you exactly what I mean by labels. I'll show you examples of it. But in Canada, women's labels, one of the ways that health hazard information is made available to anyone using the material. Labels are important because they are the first alert that hazards may be associated with the product and therefore be covered by women's legislation. The labels also tell us what precautions to take when using the product, and labels must inform the person that there is a safety data sheet available, which contains more detailed information on the product. Again, it's one of those things where, the idea isn't necessarily being a dictionary and knowing everything about that specific product. It's identifying and saying, look, I understand if there's a label on it and there's a pictogram, I need some training on this. It's not just some inert water or whatever it is. There's a health effect that can affect me. And that's really important to make it as simple as possible. They don't have to know everything about it. They just have to know, I need to go get more information. I need to go get more training. Another question on labeling. What is the purpose of labeling? For WHIMIS, I mean. Labels tell what precautions to take when using. Labels are required under government regulations. You can relabel at any time when there's a change in substance. Tells you that there is additional information on the SDS, all the above, or F, A, B, and D only. Please go ahead and record your answer, and we will discuss. Okay, we got some E's, we got some F, got another 2 E's coming in. A lot of E's. Yeah, so I think that's it. So the best answer here is F. And the reason being is number C is knocked out. You can't relabel anytime when there's a change in substance. There are specific rules associated with some of that. So bit of a tricky question again. And one of the things that labels are important because they're the first alert that hazards may be associated with using the product. So the idea is you don't want to be mixing products in different containers. So the idea is you want to be following A, B, and D. So taking a look at labels, these are the supplier labels. There are 2 labels associated with WHIMIS. Again, I'll show you exactly what I mean by this, but there's a supplier label and there's a workplace label. We're going to take a closer look at that, just so you're made aware of what they look like, what to look out for. And labels must, they have some very specific requirements. So the language here in Canada, they must be in English and French. They could be separate labels. They could have the information on a single label. WHIMIS doesn't really care about that. It's just make it available in the 2 official languages. It has to have a section about the product identifier, what the brand name is, the chemical name, the common name, the generic name, or the trade name of the product. So you got to know exactly what this product is. You have to know the initial supplier identifier. This is the name and address and telephone number of either the manufacturer of the company, of the substance, if it's made here in Canada, or the Canadian importer. Reason being, if there is any sort of spill, if there's an injury, if there's a massive environmental event, we need to know exactly who to contact. Who knows the most about this product? Generally, it's going to be the person that manufactures it or has imported that product into Canada. Has to have the pictograms. We've discussed what those look like. The hazard symbol with a red square set on one of its points. It's got to have one of the two signal words, danger or warning. Danger is used for high risk hazards, while warning is used for less severe hazards. Kind of makes sense. Hazard statements, the standardized phrases which describe the nature of the hazard posed by the hazardous product. Cautionary statement, which is a standardized phrase that describes measures to be taken to minimize or prevent adverse effects. I'll show you what this looks like. A very simple, sort of easily digestible statements with the actual precautions. And then you need to have supplemental label information. Based on the classification of the product, labels may also include supplementary information about precautionary actions, hazards not yet included in the GHS, physical state or route of exposure. The information must not contradict or detract from the standardized information. So what does this mean for us? What it means, in my view, for temporary employment agencies, we want to make sure when we are attending a workplace, when we're doing one of our site inspections or we're visiting a client, bringing them coffee, to kind of see this program in action. You want to make sure that any sort of chemicals our people are dealing with, A, you're aware that they're either dealing with them, or B, that there is training and the safety of our people are being provided. Most major companies are going to have a very established sort of program to deal with these things. You're going to have the labels, you're going to see them, you're going to have the SDS sheets available. There'll be a space in the center of the workplace or easily accessible where they have these sort of booklets and information available. So it's truly something that you do want to make sure that you don't necessarily have to know all the nuts and bolts of it. You do want to make sure that your client is doing it well. So what does the supplier label look like? This is an example of it. You're going to have, again, those sort of required elements to it. There's going to be a product identifier. So what's the name of the product? You're going to have the pictograms associated with this particular product. You're going to have your signal words. So this one says danger. You're going to have your hazard statement. Again, very sort of easily digestible sort of hazard statements. Fatal if swallowed, causes skin irritation. You're going to have your precautionary statement, what to wear. So in this case, wear protective gloves, wash hands after use, do not eat or drink smoke using this product. And then at the end, at the bottom, you're going to have your supplier distributor information. So again, who made the product or who brought it into the country is going to be on the supplier label. Supplier labels do not necessarily have to look like that. They just need to contain those elements to them. It is truly up to the either manufacturer or importer to provide this information. So aesthetically, it may look different, but as long as these points are on here, all these categories are on here, it will be compliant. This is what a workplace label looks like. So a workplace label is a pared down version of the supplier label. It's going to have 3 essential points to it according to the GHS. You're going to have the product name. So it needs to match what the SDS product name is. They have to match up. So one is the official name and the other one is more of a trade name. That wouldn't be acceptable. They need to match up with what's on the SDS sheets in the company. You need to have the safe handling precautions. It may include a pictogram, it may not. It may include other supplier label information. It's more at the discretion of the company doing it. But as a baseline, as a foundation, you need to have safe handling precautions for it. And lastly, a reference to the SDS sheets. So it's basically saying this is a product that is within our WHMIS program. There is going to be an SDS sheet. There is going to be precautions to it. It's drawing your attention to that. So when is a workplace label used? There's 3 different scenarios where a workplace label is used. It's used where a hazardous product is produced or made at the workplace and used in the workplace. So it could be, something that is produced actually there. You're not actually shipping it out anywhere. You're producing it on site. Hazardous product is decanted. It's transferred or poured into another container. So if you're taking it from a big 60-gallon drum and pouring it into, a squirt bottle that's more manageable to be used on the line where you're working, that is a scenario where you want to be putting workplace label on, because you're taking from the big drum, pouring into the smaller thing. You want to make sure people are aware of what the smaller thing is, that it's not water. It's actually a harmful substance. And if a supplier label becomes lost or unreadable. So if the supplier label, just from getting used, you can't read it anymore, you need to provide a workplace label. There are two situations where a label is not necessary. They are when a hazardous product is poured into a container and it's going to be used immediately. So if you're going to use up the whole amount of the product you're pouring into the container, you don't have to put a label on it. Or if it's under the control of the person who decanted it. So for example, if it was me and I'm taking the product from the 60-gallon drum, and I'm going to be the only person using it, I'm not going to leave it for the next shift. It is just for my use, and I'm going to probably use it up in that shift. I don't have to apply a label. The hazard statement. So each hazard class has an assigned hazard statement. And I referred to them a bit earlier, but very simply, easy digestible sort of comments. Extremely flammable gas contains gas under pressure, may explode. Fatal if inhaled, causes irritation, may cause cancer. They're not supposed to be written, so in depthly or have the lawyer write it where no one can actually understand what it means. So the idea is, again, easy digestible. Even if English is not your first language or French is not your first language, you can see in basic language what this is. The official thing, hazard statements are brief standardized sentences that tell you more about each exact hazard of the product. Statements are short, but they describe the most significant hazards of the product. We have another multiple choice question. What does SDS stand for under WMIS 2015? Is it safety data sheets? Is it safety directive statements? Is it safety decree sheets? Safely dictate sheets? Please go ahead and answer. So overwhelmingly, the answer is A from the group. Safety data sheets, and that is correct. Absolutely correct. So great job, everyone. So what does the SDS stand for? Safety data sheets. It's a document that contains information on the potential hazards, health, fire, reactivity, and environmental, and how to work safely with the chemical product. In Canada, every material, every product, the chemical that's controlled by WMIS must have an accompanying SDS sheet that is specific to each individual product or material. Both the product name and supplier on the SDS must match the material in use. And we kind of referred to that earlier. SDS sheets and the label have to match up what that name is. It's important to make the distinction that SDS are prepared by the supplier or manufacturer of the material, not by the workplace. It's intended to tell what the hazards of the product are, how to use the product safely, what to expect if the recommendations are not followed, if accidents occur, how to recognize symptoms of overexposure, and what to do if incidents occur. It is what we were referring to earlier, the supplier labels, essentially one sheet in most instances, maybe two. The SDS sheets can get quite long. They get very technical in some cases, but they are, okay, so we've had an accident with this particular chemical. What do we do now? The WMIS Worker Education Program. So education programs got to include instruction in labels, SDS, hazard information, procedures, use, handling, storage, disposal, presence of hazard materials, and emergency procedures. And that's the baseline of the product. And typically in our industry, we handle this information with regards to what labels are, SDS, kind of the information we're going through today. You want to provide the written account of how to deal with the product. So what's the written account of it? Generally, we offload the practical aspect of the chemical itself to the customer. And again, I want to stress, probably put that in your contracts to make sure they're doing that they're doing for your own due diligence, that they're doing training on the products that the customers are using. And the reason being, again, we've discussed it before, but you're not going to know every chemical. You're not going to be aware of every chemical that the client is using. So the question comes up, who needs to take WHMIS? And the answer is that the law requires that the employers educate a worker exposed or likely to be exposed to a controlled product. An exposed worker is any worker who stores, handles, uses, or disposes of a controlled product, or who supervises another worker performing these activities. What does that mean? It means anyone within the general vicinity that may use that product, that may be exposed to it, or otherwise come into contact with it, whether it's through the air or through touching it, or just through general usage of it. They have to be trained on WHMIS. So when you're training people on WHMIS, you may not have to train all the people. If you have someone that works offsite at home and they never actually touch a chemical or substance, they're working as a computer programmer, you may not need to train them on WHMIS. Your company is going to want to do its own sort of risk analysis, whether or not that person should be trained. But by letter of law under WHMIS, that person may not need to be trained. Another question I get often is, after worker has completed the education program, is any follow-up or testing required? And the answer is yes. As the employer of record, it is expected to try to ensure that the worker has understood the training material. So that means you want to have some test associated with the training, and is able to put in practice what he or she has learned. It's left to the individual to devise the means to ascertain that a worker has been properly trained. Again, that's more of a risk analysis for the company, for your company itself. Like, has this person retained the knowledge that I've told them, or retained the knowledge from the video or the online module that you provide to them? Can they regurgitate that information? Can they put it into practice? And this is supposed to be done yearly for WHMIS. Okay. What are the employee responsibilities for WHMIS? So the employees don't get off scot-free. We've just had a dozen slides on responsibilities of the employer, training, so forth. What's the responsibility of the employee? Employees, workers need to participate in education and training sessions. So if the employer deems it's necessary, as I was saying earlier, if you're going to be exposed to the product, you got to be trained on WHMIS. And the employees need to follow the safe work procedures established by the employer, as well as the customer site. So employees need to function within the company rule. So if the company says you must wear safety glasses when using their product, the employee has to wear safety glasses. The employer is responsible for every reasonable precaution for the safety of that employee. If the employer decides that safety glasses are necessary, the employee has to wear them. As well, employees, workers should work in compliance with the Act and regulations, wear prescribed PPE, clothing, equipment, and report any hazards, machine defects, or any contraventions of the Act to the supervisor. So same as the employee responsibilities overall, but specific to WHMIS, they do have to take the training. They do have to follow the company procedures. Okay, so this is about the halfway mark. I'm going to suggest we take a 5-minute break. So for me, it's 2:05 right now. We'll be back at 2:10. Go get a coffee, go stretch, check your emails, but we'll be back live at 2:10, okay? Okay, so welcome back, everyone. Hopefully everyone was able to get a stretch, get a drink, get a coffee, whatever you may need. We do, again, this is about the halfway point. We'll get through the rest of it fairly quickly. I think we can get it done in probably the 3:15 by now. We're going to be taking a look at unsuspecting hazards and hazards in the workplace. And we're going to be going into detail about some of the different categories of hazards and what they may mean from an employer perspective. And what we have here is we have another case study, and I'm just going to read it to you. And if you can take 1 minute and answer the questions. What we're looking at is 3 workers who are working on an asbestos abatement project at a single family home. The abatement area was enclosed. In the area, certain asbestos containing materials had been removed, and there was an asbestos dust hazard present. Ministry of Labor inspector attended and conducted an inspection. The inspector found one of the workers exiting the enclosed area wearing street clothing. 2 other workers were found inside the enclosed area not wearing protective clothing. One was performing cleanup, and the other was securing bags filled with asbestos-containing material. The Ministry of Labor eventually charged these people. The company was fined $25,000 for failing to ensure the only persons wearing protective clothing and equipment enter a workplace or work area where there was asbestos dust hazard. And lastly, the interesting part of this particular case study in Ontario is the supervisor was fined $4,000 after pleading guilty to failing to ensure workers use protective clothing and equipment. So just quickly, my question to you is, what would you do if filling this order for your customer? What steps, just briefly, what steps would you have taken to prevent this from happening? What could you have done to ensure that your company wasn't on the hook for the $25,000 fine and you weren't on the hook for a $4,000 fine as the supervisor? Please go ahead and record your answer. I'll give you everyone about a minute and we'll discuss it after. So what would you have done as a temporary employment agency differently than this? Would you have supplied the workers there? Would you have done any sort of training on this issue? Would you have gone to see this work site? Okay, so we do have a few different answers. One of the answers, make sure that workers have asbestos abatement training. Absolutely, that's great. Anytime you're working with anything as dangerous as asbestos, training is essential. Someone else said the work area should have been taped off. Someone said that they would not have taken on this project. It's probably a very, very good idea. Everyone's trained and the area is walled off. Yeah, those are great answers. And clearly some of you have either been involved with asbestos work or you've taken a look at this. Asbestos is one of those chemicals, and we'll get into exactly what I mean by it, but it's one of those chemicals where there is no safe. Someone says they renovated houses. So yeah, especially if you've renovated old houses, you've probably been concerned about asbestos. Asbestos, again, there's no safe limit of using asbestos. Some people can be around asbestos for their entire life and not develop any symptoms. Some people can have very brief exposures to asbestos and develop, some pretty significant lung issues and whatnot. A lot of times they say anyone that has any sort of respiratory illness already is going to be more susceptible. People that smoke cigarettes, they have found to be more susceptible to that. But that's not the rule. Again, there's no sort of acceptable limit to being exposed to this. So it's truly like it's a product that was involved with most, the person that said they were renovated houses, they used to use this exclusively up to about the mid 70s. And it worked great. They used it in everything. It was in shingles, it was in wall boards, it was in paint, it was in ceiling tiles, it was in floor tiles. And the reason being, it had a fire retardant effect to it. So essentially, it was so hard to burn these things. And so they thought that it made the building safer and less likely to burn down. But what they were not aware of at the time, or at least not as aware of now, was the fact that when asbestos gets airborne, again, people have very poor effects from being exposed to it. And again, someone could be exposed to a very minor amount and still have very harmful effects. So as a society, we've learned from our mistakes in the past and developed some very specific sort of health and safety precautions for dealing with it. And some of those ones, again, and the answer is, I don't know if I covered everyone, but they said to, wear the PPE, wear your respirators. The other thing that we have to be aware of, if we are supplying temporary labor to any company, so a restoration company or an asbestos abatement company, there are very specific rules associated with that. And it includes, depending on the jurisdiction, it depends on how much asbestos is present. But it is a requirement to wear PPE, respirators, not be in street clothes, as was pointed out in this case study, to have essentially walled off areas where you're not able to enter and exit the asbestos containing area. They have, some HVAC filters that'll remove airborne or friable asbestos in the work environment. And so I think one of the reasons that this is brought up in this training is just to make sure that everyone that is involved with this in any sort of labor, supplying labor to the work environment, if you are going to be dealing with asbestos, you're going to want to ask a lot more questions of the customer. Make sure that they are a customer you are very confident in, are doing their due diligence and following the Ministry of Environment regulations and the Ministry of Labor regulations. Because again, the effect of this is it could be a very minor exposure, but someone could have a very serious life-altering sort of reaction from being involved with it. And so we kind of transition to what are designated substances. A designated substance is something very specific. In Ontario, we have this term called designated substance, and we have a regulation associated with what this means. Designated substances are biological agents, chemical agents, physical agents, or some sort of combination of the above. It is the regulation itself discusses that the designated substance to which the exposure of a worker is prohibited, regulated, restricted, limited, or controlled. And they list out a number of these designated substances, and there's very specific rules associated with dealing with that. And asbestos is labeled as one of those. So there are hidden hazards in our workplaces, homes, schools, and even products that we use. As one of the comments, I think I saw, one of the comments was that asbestos was used as fake snow in the 30s, 40s, and 50s. It probably did very well as fake snow. Fake snow, probably functioned as fake snow. But it is something where people that were working, let's say in movies or film or theater sort of settings, they would have been exposed to that. And now we know that we have the right to refuse unsafe work. We have, much more solid health and safety systems to deal with these sort of substances that we as a society have looked at and said, look, these are over and above just dealing with, something like simple household bleach. There's a separate regulation for the chemical agents, and we'll kind of show you exactly what that means. But the designated substances regulation regulates exposure to designated substances in the workplace and outlines different ways to control the hazards posed by those substances. So again, we've delineated that these substances are serious. that they have ongoing or catastrophic health effects. And we've made sure that we have, as a society, developed processes and procedures for dealing with it. So this is a list of the designated substances. In Ontario, it's listed as Regulation 490. Every province has something close to this. In Ontario, they're a little bit more defined in how they refer to these things. And when a designated substance is present in the workplace, there are very specific things that need to happen. So of course, you're going to have your PPE and so forth. You're going to have a supervisor complete an assessment of the use. The assessment is to determine if a health hazard exists for workers or whether or not a control program is required. The assessment is going to include information on the use, handling, storage, and disposal of that substance, actual and potential exposure of workers to the substance. So how likely are they to be exposed to the substances? Methods and procedures required to control that exposure. The Joint Health and Safety Committee needs to be involved with that assessment. So they're going to be either referred to or they're going to be involved at some level, whether it's the final report. And when a designated substance is in the workplace, the assessment that the supervisor does is to determine if a health hazard exists for workers and whether or not a control program is required. And again, you may have an instance where a designated substance is in the workplace, but it may be only used or exposed to a very small amount of people. It could be in its own isolated room. It could just be a process that is controlled by machines, and so there's very little human involvement. But every workplace has to make that assessment for themselves and decide whether or not, hey, do we need a full program? What's that program going to look like? And what do we need to do? And just going through some of these, we have, I can never say this one, acrylonitrile. It's used primarily in the manufacturing of synthetic polymers, such as acrylic fabrics found in carpets. So obviously a manufacturing type of environment, if you're making rugs, if you're making any sort of products with acrylic fabrics. Arsenic is a strong poison. It's used typically in wood preservatives, insecticides, and herbicides. Arsenic is also used in alloys of copper and lead. Asbestos, I think we discussed that. A lot of household products, a lot of products used in schools, in the early 50s and so forth. And a lot of times, just based on how much they were used, insulation, wallboard, asphalt, adhesives, caulking, sealing, floor tiles, gaskets, drywall compound, especially roofing shingles. Essentially, the whole house was built in asbestos. If you have an old house, very good chance if you're doing any work on it, you may want to make sure that you're getting these things tested for asbestos. Benzene is used to make other chemicals, which are then used to make plastic, resin, nylon, rubber, lubricants, detergents, drugs, and pesticides. Benzene is a natural component of crude oil and gasoline. Ethylene oxide is used in ethylene glycol, surfactants, fumigants, fungicides, and petroleum emulsifiers. Coke oven emissions are airborne constitutes of the byproduct created by destruction, distillation of coal and petroleum. Isocyanates are typically used in spray foam insulation, sealants, finishes, paints, and auto body materials. Lead, another old sort of product used in almost anything, was used in paint, mortar, old water pipes, lead sheeting, and contaminated soil. Mercury is found in fluorescents, switches, pressure gauges, electrodes, and contaminated soil. Silica is typically involved in anything ground related, so bricks, blocks, granite, abrasives, concrete, sandstone. And lastly, vinyl chloride is used to manufacture PVC, which could be used for, PVC is basically anything, any plastic sort of piping. So it could be furniture, upholstery, plastic pipes, wire, cable coating. So what are these things? These are, they're nasty chemicals. They need to be controlled somehow, or people could be potentially hurt. What that level of risk is, the customers, the employers have to decide. And vis-a-vis, we have to take a look at what customers, if they are involved in this type of work, if they do have a designated substance requirement, what are we doing as a temporary employment supplier to make sure that our employees are safe and that we don't have problems in the future because we're not doing what we need to do for exposure to that sort of program. So what do? You may want to make sure that A, your client has the necessary programs in place. B, maybe you're not just, maybe you're going to decide not to supply to that particular work area, or, bigger, maybe you just don't supply to that client. And that's going to be a risk factor of your business, deciding, okay, what level of risk are we comfortable with, and what level of protection are we going to supply to this? Like, how are we going to control these hazards? So we're going to take a look at other hazards in the workplace, and we're going to go through a number of them. So other hazards in the workplace, confined spaces is number one. These are in no order. They're just other hazards to point out. Confined space is something that is typically an area that is not meant for human occupation. It generally has limited means of air supply. It has generally limited means of getting in or out of that workspace. It could include anything like a silo or a vat or a hopper, tank, sewer pipe, truck or rail cars, aircraft wings, boilers, manholes, manure pits, storage bins, even possibly ditches and trenches may be considered a confined space. And there are very specific rules in, I believe all the provinces have very specific rules assigned with confined space. And the reason being is you're sending someone into an area where humans generally aren't supposed to be. There's probably not a lot of air. So if there is an instance where an accident occurs, it's going to be pretty serious pretty quick. You're going to have to be able to take that person out of that workplace while making sure that the people taking them out of the workplace are safe as well. So in the case of like a gas leak or something, and you're in a shaft as this picture is, anyone going down there is going to be exposed to the same level of the gas, and is potentially going to create a bigger hazard. So our governments, in I'm pretty sure all jurisdictions at this point, have rules and regulations surrounding confined space for those reasons. Indoor air quality, that is definitely something that we're all very aware of, dealing with COVID for the last couple of years. Indoor air quality is the new sort of thing as we move back into the workplace, as our kids move back into schools, has been a topic of conversation, and it involves something that we do all the time. We're always breathing, right? We're breathing more than we do anything else at any time over the course of the day. So we as humans want to, or we should have a vested interest in making sure that our air quality is as good as it can be. Indoor air quality can include improper or inadequately maintained heating and ventilation systems. So whether they're old, or they just don't have functioning filters, or they're not exchanging the air quick enough. It could be contamination from other things, construction materials, other work areas. It can be, again, because we are breathing so often, the effects are typically heightened because we're doing it so many times per day. And it could be from, again, all these different things can produce indoor air quality that is unacceptable, as can sickness or illness or viruses. Lasers, the problem with lasers typically, or most commonly, associated with eye and skin burns, which are due to the laser beam shining on a person's body. So whether it's directly in the eye, or it's one of these high-powered lasers that they use in industrial settings, where you can get a significant burn pretty quick. Non-beam hazards are associated with the laser equipment, or the hazardous substances released from the laser equipment. So basically the fumes associated with the materials exposed to the laser beams. So now you have a secondary hazard where you're actually breathing in whatever the burned or fumed substance of the thing the laser is cutting. Moving on to scents. Scents usually mean the smells or odors from cosmetics or other products, such as air fresheners and cleaners. This is a little different than indoor air quality in that it is usually someone is wearing something. I'm sure we all know of someone that has a scent sort of, not allergy, but like a proclivity towards, strong scents will make them sick, or they give them headaches, or make them nauseous. And some of this, some of the companies out there have a no-send policy for these reasons, because you're dealing with all sorts of different employees in the same area, and they don't want obnoxious scents, whether it's perfume or cologne or whatever it may be, to be impacting other people in the work environment. Temperature is another big one. Temperature is the number one complained about thing in offices. Some people like it a lot hotter than the office is. Some people like it a lot cooler. And historically, it's been something that has been the number one sort of complaint when people are confined into an office environment. The other thing with temperature, in very hot temperature, the hazard is a heat stroke issue. Someone getting, past the point or overheated to the point where they can no longer function. As well as in a cold environment, you can have actual things of, cold effects such as hyperthermia. You can have frostbite. There is no maximum temperature specified in the legislation. So it's not like if it gets to 40 degrees, we have to do X, Y, and Z. They actually don't specify that in occupational health and safety. Where they do specify it is for low temperature. So, every sort of area has different designation of what the low temperature is. But it's definitely something where in our environment, we want to be cautious if we're having someone that works in the cold temperatures. So if it's construction workers and they're outside, if it's forklift drivers and they're coming in and out of cold areas, whether it's outside or like freezer areas, we do want to be very concerned that there are protocols in place and PPE, so that they're wearing, let's say, jackets, let's say gloves, let's say hats or toques or whatever. We want to make sure if our people are being supplied in that type of work environment, we're taking a look at the work environment and ensuring that the clients are doing so in a safe environment. Ventilation probably coincides with indoor air quality, I believe. Mechanical system in a building that brings in fresh outdoor air and removes the contaminated indoor air. We do want to be exchanging air all the time. Our houses typically have air exchangers, whether it's passive system or a more active system. So it's really important in the workplace that we do have these sort of similar systems. That ventilation is used to control airborne contaminants by removing the fumes or the dust or the vapors in order to provide a safe and healthy work environment. Weather is another hazard that we have to deal with. We live in Canada. We're, I'm sure, very conscious of weather. We have snow and ice and rain, and we have that all in the same week sometimes. As an employer, you can see where that would be a hazard. You have people coming in and out of vehicles. You have people coming, into your work environment. So, are you making sure the parking lot's safe? Are you making sure that the work environment for all the people is safe when there is, let's say, ice, or there's slippery environments, or there's hot environments, or there's lightning, potentially providing driving tips for poor weather. And lastly, the last hazard we'll look at is working alone. And it's not to say that all these things are hazards. Working alone especially, it could be seen as a hazard. It really depends on the work environment itself. It's not always hazardous to work alone. It can be when other circumstances are present, such as someone, based on the location of the work or the type of work, if they're interacting with the public, if they're dealing with money or they're dealing with high value goods and they're working alone, you're going to have different sort of requirements for looking at that as a hazard. The example I always give for this is a gas station attendant. So when they're working late at night by themselves, they have money in the till, they have convenience products behind the area, and it's nighttime, they're working alone again. A lot of those places, that was the one that they used as an example of working alone. Some provinces do have very specific rules associated with working alone, where you have to have a process in place or a procedure in place. Other provinces look at it from more of a general duty clause to make sure, even though this person's working alone, they're working safely and they're working compliant with your policies. So again, very high level look at hazards, covered a lot. It's obviously impossible to cover every sort of hazard. Every work environment is going to have their own set of specific hazards based on their environment, based on the product they're using, based on what they're manufacturing, based on the people there. It's important that we understand what the hazards are and that we are providing controls to those hazards to ensure our people are as safe as they can be. And we're ensuring that the client themselves are doing the same for us. We're going to be taking a look at hazards, workplace harassment. This is viewed as a separate and distinct sort of area. Most provinces at this point have a carve out in the Occupational Health and Safety Act for workplace harassment, violence. And what does that actually mean? It's our role to ensure workers are exposed to a happy and healthy workplace. And starting in, I believe, 2009 in Ontario, there was a major issue where a nurse was killed by a doctor. There's a lot of things behind it, but essentially what happened was this person was being harassed in the workplace. The hospital did nothing about it, and eventually the doctor murdered the nurse. There was some sort of relationship involved between the two, and eventually, the employer wasn't required at the time to look at those signs. But what happens sometimes when you have these egregious events is that the response to it is, okay, we need to provide legislation. So all employers now have to take a look at this and deal with harassment and violence in the workplace. And this is one of those things where it was, again, an egregious event. And now all employers across Canada at this point have to have harassment and violence procedures in place. It depends a little bit on each province what you have to do, but essentially you need to have some sort of mechanisms in place. And the workplace violence and harassment program, it's got to include a few different things. It's got to have measures and procedures for controlling risks, ensuring there's immediate assistance when workplace violence happens, and how workers report incidents of workplace violence. Just like in unsafe work via physical work environments, workers have the right to refuse work if they have a reason to believe they're in danger from workplace violence. And that's a big one. So if you do have some sort of altercation in the workplace, you have to ensure the safety of that, the participants involved, whether they were the instigator or whether it was the other way and the person at the other end of the harassment. And then recently we've included, at least in Ontario, we've included another section on sexual violence and harassment in the workplace. And what OSHA did was they defined workplace harassment will be expanded to include the workplace sexual harassment. So it includes all the things we discussed earlier, but now it includes the sexual component of it. Workplace harassment, so it's engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought to reasonably be known to be unwelcome or workplace sexual harassment. And what does workplace harassment mean? It could mean something to everyone. So the example I always give is if you tell a joke to 5 people, 4 people may think it's the funniest joke they've ever heard. One person, because of their history or because of their experiences, may be deeply offended by that joke, and they may view that joke as harassment in the workplace. So it is the experience of the person, the recipient, whether or not they view it as harassment or violence in the workplace. For some instances, violence is a little more clear cut. We'll get into what exactly violence is on the next slide, but harassment is a lot of times it's a little more deeper in the activity of the employees. It could be things like making remarks or jokes or innuendos that demean, ridicule, intimidate, or offend people. It could be displaying or circulating offensive pictures or emails or jokes via email. It could be bullying. It could be repeated offensive or intimidating phone calls or emails, or it could be directly workplace sexual harassment. Most of the provinces that have defined workplace harassment have a carve out for what workplace harassment is. And here in Ontario, the idea of what isn't workplace harassment. Workplace harassment isn't a reasonable action taken by an employer or supervisor relating to the management and direction of workers. So a supervisor telling someone you have to make 60 widgets, you're only doing 40 widgets per hour. You need to step up your performance. that is not viewed as harassment under the Occupational Health and Safety Act. Other items that are reasonable management actions that would be part of the manager or supervisor's normal work function and could include changes in work assignments, scheduling, job assessment and evaluation, workplace inspections, implementations of health and safety measures, and disciplinary action. So a supervisor functioning as a supervisor by ensuring the employees are doing what they need to do, whether it's a scheduling change or whether it's a work process, that's not harassment in the workplace. And a lot of workers may not understand what this exactly means. Workplace harassment in the legal definition is different than what someone might more plainly view as harassment. So supervisor always on you to make your production quota every day. Yes, that is harassing to you. You may experience it as harassment, but as a legal definition under the Occupational Health and Safety Act, it doesn't actually breach that level. What is workplace sexual harassment? It means engaging in a course of vexatious comment or conduct against a worker in a workplace because of sex, sexual orientation, gender identity, or gender expression, where the course of comment or conduct is known or ought reasonably to be known to be unwelcome. Or making a sexual solicitation or advance when the person making the advance is in a position to confer. Essentially, what this is a power dynamic. So if a supervisor is saying, you know what, you want that, you want your vacation, and making a sexual advance to the employee with the prospect of getting that vacation, that is workplace sexual harassment. It can also include other things. It could be asking questions, talking, or writing about sexual activities. It could be rough or vulgar humor or language related to sexuality or sexual orientation or gender, displaying pornography, sexual images, or offensive sexual jokes in print or email form. Leering or inappropriate staring, invading personal space, unnecessary physical conduct, including inappropriate touching, demanding hugs, dates, or sexual favors, making gender comments about someone's physical characteristics, verbally abusing, threatening, or taunting someone based on gender or sexual orientation, or threatening to penalize or otherwise punish a worker if they refuse a sexual advance. When the conduct or behaviors includes inappropriate sexual touching, this may also constitute a criminal offense such as sexual assault. Obviously, a very big sort of repertoire of what sexual assault is in the workplace. It is something that is, should be under every company out there, completely and wholly unacceptable. You've probably seen a movie from the early 50s or something where we weren't as advanced in this area as we are now. And that is unacceptable to anyone in the workplace. And our Occupational Health and Safety Act has risen to the level to say, look, all these things are unacceptable. And they are unacceptable when the recipient believes they are unacceptable. And it is how the person receiving it, in many cases, view that incident and whether or not it would be construed as sexual harassment. Again, my example earlier, you could have the same joke told to 5 people, 4 people think it's funny, 1 person does not. It does not mean just because 4 people thought it was funny that it wasn't workplace sexual harassment. Obviously, when you're dealing with this, if you are dealing with this with one of your temporary employees or associates, you want to make sure you are doing it properly, investigating properly. And again, if it constitutes a criminal activity, get the police involved, immediately once you know about it. So no one wants to deal with this. You may want to seek legal counsel. That's not the purpose of today's module today, but it is to draw your attention that there are very specific things associated with this in the workplace. Moving on, workplace violence. Workplace violence is the exercise of physical force by a person against a worker in a workplace that causes or could cause physical injury to the worker. Could be an attempt to exercise physical force against a worker in a workplace that could cause physical injury. So it doesn't even necessarily have to be a physical act of, say, punching you. It could be throwing a shoe at a person. That would be viewed as workplace violence in most cases, I believe. And lastly, it could be a statement or behavior that is reasonable for a worker to interpret as a threat to exercise physical force. So that would be some sort of threat. I'm going to fight you in the parking lot after work. All those things do include workplace violence. What level of violence they are Again, this is one of those things where you do need to investigate these issues thoroughly. Workplace violence can include verbally threatening to attack a worker. Could include leaving threatening notes or sending threatening emails to a workplace. Could involve shaking a fist in a worker's face, wielding a weapon at work, hitting or trying to hit a worker, throwing an object at a worker, sexual violence against a worker, kicking an object at a worker, or trying to use some sort of equipment to harm a worker. Again, a very big sort of repertoire, I guess, what workplace violence is. Obviously not as big as harassment. Harassment is something where it's usually not, how many first? You usually don't see workplace harassment in the same level of workplace violence. It's very easy if someone throws a shoe at someone, other people are going to view that as acceptable. Workplace harassment is sometimes unseen by other people. It may be, a one-on-one sort of thing. And anytime you're dealing with workplace harassment, you do have to investigate it. In Ontario, you are required to investigate it. You're also required to issue the results of that investigation. So after you're done with your workplace harassment investigation, you have to send some sort of note to the person making the allegation and the person that was presumably doing the harassment, or at least accused of it. You have to send them a letter or a report or some written documentation stating the outcome of the event and what the steps are the company is going to deal with it if there is some sort of issue. So just bear that in mind. And the way I've always trained it within our own company is if you're dealing with any situation where there is workplace violence, harassment, sexual harassment, or sexual violence, you want to immediately get other people involved. You may want to get your senior managers, you may want to get your HR involved. If you have legal representation at your company, you may want to get all those things should be under consideration. What you don't want to do is nothing. If you are told by one of the employees, temporary, full-time, part-time, contract, it doesn't really matter. Any of those events, if you are experiencing them, I would definitely recommend getting other people at your company involved. Kind of switching gears here, we're going to look at hazardous sound levels. So another sort of hazard in the workplace. As we look at this slide, it says what OELs are. OELs are occupational exposure limits. It's the maximum level that you can be exposed to a sound for an 8-hour shift. Here in Ontario, it's 85 decibels for an 8-hour shift. It does allow for differences. So if you have 15 minutes of exposure at a level of sound that is 105 decibels, that would be acceptable as well. You want to be looking at what the criterion is, which is the steady noise level. So what is the ambient noise of that workplace for the full 8-hour shift? If you are breaching the level of 85 decibels per decibels for the entirety of that 8-hour shift, that work environment needs some sort of sound protection put into place, whether it's the earmuffs, as the picture shows, some sort of ear protection, or working on the machine to reduce the noise at that level. And every province has their own sort of criterion. How loud can it be? But they all hover around 85. I mean, that's just based on science. Basically, how long can someone be exposed to a noise without creating an ongoing health defect or AFEC? And then secondly, the exchange rate, the amount by which the permitted sound level may increase if the exposure time is halved. So if you're exposed to noise and it's above 85 or it's around 85 decibels for only 4 hours, that would be seen as acceptable. There are sound tables associated with it. It's a very specialized sort of occupational health and safety field. You're typically dealing with hygienists or audiologists or something of that nature. People are very specialized in this. So it's not that we need to be cognizant of it, but if our client does have hearing protection requirements, we want to make sure that, again, our people are provided with that hearing protection, that they're wearing it, and that they're wearing it in the appropriate fashion. First aid requirements. Employers rather, and customers must provide the following in the workplace. First aid equipment and services. They do have to be inspected quarterly. We need first aid stations must be easily accessible and your worker has a valid first aid certificate. What this means is if you need to have your first aid station close to the person that actually has the first aid certificate. You can't have it on the complete other side of the manufacturing place. You need a notice board displaying first aid poster, first aid certificates, valid first aid certificates of qualified trained workers on duty, and the kit inspection card must be made available. And there must be detailed records of all incidents and first aid treatment given. This is a very specific to Ontario, at least the numbers are. Every province has their own title for what the standard first aid is called. Some of them, they all call them slightly something different. In Ontario, for workplaces with 6 or more workers on any shift, a standard first aid certificate is required. First aid stations are under the care of the worker with a valid first aid certificate at all times. Should be able to reach an injured worker, ill worker within a 2-minute walk. What this means, if you have a big shop floor, you should have multiple first aiders dispersed throughout the work area. And in most jurisdictions at this point, CPR is a mandatory module as part of the first aid training program. So don't get too involved about the numbers. Your province, if you are from a different province in Ontario, will have its own and very easily accessible. Most of them are linked to the workers' compensation. They are having changes where we're going to basically unify what a first aid kit is across Ontario. Different provinces are in different degrees of it. And, but essentially, again, it's one of those health and safety realizations that everything should be standardized across the country. Again, ease of logistics, make sure everyone knows about it, as well as easier for companies to really manage these things. OSHA and critical injury. Critical injury is defined as any injury that is serious in nature and does the following. Places a life in jeopardy. Very vague statement. I don't know what that means, but it is definitely something where if a life is placed in jeopardy, it is defined as a critical injury. If it produces unconsciousness of the person, it results in a substantial loss of blood. Again, I don't know what substantial means, but if it happens on your work site or to one of your employees, you're going to have to make that determinant. Was that a substantial loss of blood? What did it place a person's life in jeopardy? And you want to make sure you have documentation on why you made that decision. If it involves the fracture of a leg or arm, but not a finger or toe, it involves the amputation of a leg, arm, hand, or foot, but not a finger or toe. Consists of burns to a major portion of the body, again, not defined, or causes loss of sight in an eye, so one eye. So when do you report a critical injury? When a critical injury occurs, the employer must notify a Ministry of Labor inspector immediately by telephone and contact a member of the Joint Health and Safety Committee. They must conduct a thorough investigation. Section 51 of the OSHA requires that all critical injuries be investigated, and then a written report must be prepared and forwarded to the Ministry of Labor within 48 hours. So the timeline, as soon as you're notified of someone having a critical injury, if it's one of your temporary employees, if it's one of your staff, you need to make sure you understand whether it's you reporting this critical injury or whether it's the client, because there is no ability to say, oh, I thought the client was going to report it. It's their workplace. I didn't know. You just want to make sure that you're communicating with your client at that time to find out exactly who's reporting and make sure it is reported. A lot of times what happens is the client reports and the agency reports just to make sure that the due diligence is done. We have a scenario. There's going to be a couple questions on this one, so please listen. A new client places an order for a general labor. It is the final assembly line that wraps and boxes cans of cat food. They will then lift the newly packaged box and put it on a skid. Another worker will use a forklift to pick up the skid when it is full. The customer tells you they run a very safe operation and have won a safety award. Training will be provided around their safety procedures. Safety boots are required and gloves will be provided. After the second week, your employee placed on the assignment tells you that they will not return. You ask them why. The reason being is the equipment that is used to put plastic wrap on the case of food is blocked, and they want you to push the product through with your hand using more force than you're able to provide. You'll also ask that in the absence of the forklift driver, you operate the forklift and move the skids to a designated area. You refused, but the supervisor said everyone does it. Lastly, you burned yourself while packaging and your supervisor told you to be more careful. You do not feel safe and the supervisor intimidates you. So based on that scenario, can you and or your customer discipline your employee for refusing to work? True or false? Please record the answer in the comment section. We'll discuss it in a moment. Resounding false. Every answer I think so far has been false. Great answer. No, you cannot discipline someone for refusing to work when it's an unsafe work environment. If you remember back from the beginning of the course today, one of the basic rights of employees is the right to refuse unsafe work. So absolutely 100% you cannot discipline an employee for doing this. You and the customer are prohibited from penalizing, dismissing, disciplining, suspending, or threatening to do any of these things to a worker who has refused to work. Ultimately, they are following the regulations of the OSA. And again, one of the basic rights of employees is the right to refuse unsafe work. An employee can refuse to work at any time for the following reasons. The physical condition of the workplace or workstation is likely to endanger your employee or a coworker. Any machine, equipment, or tool that the worker is using or the physical condition of the workplace is likely to endanger, again, your employee or another worker. Lastly, workplace violence is present and is likely to endanger your employee. So how do you ensure and support your workers when they uncover a safe work environment? This is kind of front-loading the employee, making sure that they understand their basic right to refuse unsafe work. And the best way to do this is to make sure that your employee undergoes mandatory training upon hire. That includes, if at least, notification of the 3 basic rights and what they mean. You should ensure that the client site has been inspected, that there's a safe work environment. And lastly, when this does occur, you should know, and your people should know how to deal with a work refusal. True or false question. This relates back to the scenario we just read about the canned cat food. Will the employee will not be paid while refusing to work? True or false? So they will not be paid while refusing to work. Please record your answer and we'll discuss in a moment. All right, we got a false, got a true. If it depends, false. Someone says, I believe they have to be paid while it's investigated or provided additional work. Yeah, that's a great answer. So it's false. An employee will be paid during the first stages of a work refusal. During the next stage, so we'll go through what the stages are, but an employee could be asked to do additional work or other work at a different machine. You can bring in another employee to do the work who may feel that work isn't unsafe. But there are some very specific rules, especially here in Ontario, that dictate what happens during a work refusal. What are the stages of a work refusal? Stage 1. Stage 1 is, so the worker says, I don't want to work here. I feel it's an unsafe work environment. The worker must stop working immediately. So that's at the point where the worker goes to the supervisor and says, look, I don't feel this is safe for X, Y, and Z. Supervisor must investigate the situation, either in the rep or health and safety rep. The worker is to remain close to the site while the investigation is being conducted. It comes back to the question we just asked. Are they being paid? Yes, they are in a nearby area. They are hopefully not in the immediate area, especially if they consider it unsafe. A lot of times the person will be, sent to the cafeteria, sent to the supervisor's office, sent to an area where their safety is maintained. It could be that you're able to resolve the situation here, and that's the ideal scenario here. If it's something minor, if it's whatever it may be, is the solution. Upon resolution, the worker must report the incident, and they're basically saying they must report to your joint health and safety committee, and hopefully you as the temporary employment agency. The employee who's refusing work must remain in a safe place until the investigation is completed. This interval is known as the first stage of a work refusal. If it's resolved at this stage, the worker can return to work. So if you're able to come up with an amicable solution to whatever the work refusal is, this is where you want to do it. You want to make sure that you're able to hopefully satisfy the work refusal issue that the employee has raised. If, however, the situation is not resolved at this level, if after investigating and the supervisor comes back and says to the worker, no, it's safe, you should be able to do it, then we progress to the next stage. And stage 2 and 3 are essentially, different people phrase it separately. Some people just view it as a 2-stage. Essentially what happens if you can't resolve the issue at a stage 2/stage 3, the worker feels they have continued reasonable grounds to feel the worker is unsafe. The worker is able to say, look, I don't agree with you, Mr. Supervisor or Mrs. Supervisor. I don't think it's safe. I still am going to maintain my right to refuse unsafe work. At that point, what you need to do, and this is why some people say it's 2 or 3, but it's essentially, to me, they're combined. The worker, a branch person, or the customer must notify the Ministry of Labor or provincial inspector at that point. So if you cannot resolve the situation with the employee, whether it's through altering the work environment, whether it's putting them at an alternate workplace, if they're working at machine A and this particular person views it as unsafe, you can put them on machine B or machine C. And that may be something where it resolves their safety issue as long as someone else views the job as safer for them. That could be for all sorts of reasons. I could view work as unsafe where my coworker may think that's perfectly safe. That could be a physicality issue. Maybe I can't lift as much as my coworker. It could be a height issue. It could be a different sort of risk acceptance of that person. And the Health and Safety Act recognizes that and understands that, okay, at a certain point, the supervisor and the employee are not going to resolve this issue. We're going to bring in a third party, and that's the Ministry of Labor or provincial inspector, depending on your province. And what happens at that point, the inspector either comes into the workplace, they'll tell you to shut down that machine or that area, and they will either come to the workplace or they will conduct a phone call. And then a decision will be made as to whether the work will endanger the worker. It typically has to be in writing, but the decision is by the Ministry of Labor person. One of the things you don't want to be doing if you have a work refusal, you don't want to invite a Ministry of Labor inspector or a provincial labor inspector into your workplace if you can avoid it. Once they're in the workplace, they can look at whatever they want. So they may look at that machine that is part of the work refusal, but then they can go look at anything else they would choose to. It's in the interest of all parties to resolve the work refusal at hopefully stage 1. And again, this is enshrined under the Occupational Health and Safety Act. This isn't just a company policy. This is a legal requirement for companies. We're going to switch gears here. This is the final sort of section that we have. We're going to be looking at the Provincial Compensation Act, regulations associated with it. Everyone calls it something different depending on your province: Workers' Compensation Board, WSIB, CNESST, if you're in Quebec, WorkSafe NB, Workplace NL, all sorts of different names for them. They all do the exact same thing. Employees, managers, supervisors, workers, and the government all have responsibilities when it comes to workplace health and safety. These compensation boards affect when someone is injured, typically. Additionally, workers have the rights to refuse unsafe work, participate in health and safety activities, and know about dangers in the workplace. So again, this is going to be a 10,000-foot level view of the Workplace Safety Insurance Act system. And every province, they may have slightly different regulations. They're all essentially the same. They all have the exact same purpose. It's to establish an insurance plan to compensate workers. When a worker is injured and they can't return to the workplace, the workplace safety insurance system is to step in and provide loss of earnings to that person so they don't lose their house, they don't lose their car, they're not destitute, simply because they were injured while at work. It's to ensure that the worker is successful in returning to work. There's a lot of penalties associated with not returning a worker to work. We are required as employers in every jurisdiction to participate in getting that employee back to work or something suitable. In many provinces, the workplace safety insurance boards promote health and safety in the workplace to reduce injury and disease and to help facilitate the worker and recovery of workers. They function as an arm of the government. It is a system, it's an insurance system that is 100% funded by employers in every province in Canada. What that means, it's not part of the general tax base. It's the employers of that province that are funding that system. Every employer is paying a certain premium to have that insurance. It is, in most cases, mandatory. Some provinces will have some carve-outs for certain industries. There are financial and legal implications to the workers' compensation board of your province. They can do a number of things. They can fine you. They can require you to reinstate employees. They can provide or not provide. They can charge you with a criminal offense. If it goes pretty far. They have some far-reaching powers. When an employee is injured and there's a loss of work experienced by the employee, whether it's through a specific injury or an occupational disease that happens in the course of the employment, the Act ensures the employee receives support and health care by way of the following. By returning to work in his or her pre-injury position or other suitable work, the work in the pre-injury role may no longer be available or the term has ended. And that's something that typically, or not typically, but it can happen, especially in our industry where you have someone that is injured. Maybe it was a short-term week assignment, let's say. And by the time that person is able to return, that assignment is just no longer available. That job order is just, it's gone. It was for a very specific cover. We do have responsibility still to return that employee to work, even if the client is no longer, let's say we're no longer servicing that client. We still have the same responsibilities. Our role is to look for other suitable work for the worker. A lot of times this could lead to coaching or working with an individual to assist them looking for other work, potentially maybe another client, maybe another work area. It also enables compensation to be paid to the worker when a worker loses earnings. So if they are, because of a direct result of the injury, they are working less hours, they are not able to work at all, or they are required to take, a week off because of the injury, as per their doctor, the board does provide compensation to that employee. When there is a workplace injury, record keeping is critical. I had a teacher when I was really young tell me, a human resource teacher says, if it's not documented, it didn't happen. And what I mean by this, and what he meant by this, was that when you're dealing with a government agency, simply saying, well, we had that conversation and having no backup, the government agency is going to err on the side of the worker themselves. They're going to basically make a decision to benefit the worker, unless you have documentation. So documentation is one of the most critical steps when there is a workplace injury. You want to be, initially, as soon as you're notified of this, you want to make sure that you're finding out information like the date and time, name of any witnesses, nature of injury, location of injury, details of any first aid given. It's so critical to document the details of all the accidents. So even if it doesn't seem serious, you still want to document the accident or the incident itself. And that's for a number of reasons. It's preserving the evidence of the scene if it's a very critical sort of injury. People's stories may change. Witnesses may no longer work there if it was the case of, a public space or something. You want to be on these issues as quick as you can. And again, we're human, so we could experience things differently. When the employee themselves say they're injured and, they might come back and say, it's, just a scratch. They might wake up the next day and find out, what, it's more than a scratch, it's infected. I got to go to the hospital and they can no longer work in that job. And you want to make sure you've done your due diligence at the beginning, you've documented everything, you have all the information. Another multiple choice question. When there is a critical injury, so think back to a few slides ago. When there is a critical injury in the workplace, the manager is required to report the injury within 24 to 36 hours of the injury taking place to the safety group, 3 days to the workers' compensation, immediately to Ministry of Labor, 2 days with a written report to the Ministry of Labor. All of the above are B, C, and D. Go ahead and record your answers. So when a critical injury occurs, when do we have to report it? 1 day to the safety group, 3 days to workers' compensation, immediately to Ministry of Labor, 2 days with a written report. Kind of getting a lot of different answers here. It is, the best answer here is F. So we need to report it to the workers' compensation, 3 days for Ontario, but we need to report it to the Ministry of Labor immediately. So we got to call them. We have to call the hotline and say, look, we've had a critical injury. They'll take your name and number and location and some general details, and an inspector will come out and see you, or call you at least. And within 2 days, we have to provide a written report to the Ministry of Labor. If an employee is going to be absent from work or requires healthcare as a result of a workplace accident, the incident must be reported to the WCB within 3 calendar days if they lose time from work, your worker earns less than a regular day's pay, your worker gets outside healthcare treatment. So what does this mean? If they miss any time from work, it's over and above the day of the injury though. So if they miss their next scheduled shift, or if they start having to work less hours over the course of the week because of the injury, you have to report it to workers' compensation. If the worker gets outside healthcare treatment, that's by a doctor, by any regulated medical association, generally not, more homeopathic sort of investigations. So an osteopath or something of that nature. It's generally a doctor, hospital, walk-in clinic, other sorts of regulated medical industries. In Ontario, this number is specific to Ontario. You can wait on reporting the incident for up to 7 days if the worker receives modified work at full pay, or if the worker needs nothing beyond first aid. So if you're able to coordinate modified work for that employee so they don't miss any time, don't miss any money, and they don't go to the doctor, and this resolves within 7 days, you don't have to report it to the WSIB here in Ontario. So return to work and the duty to modify work. So when considering modified work, consider how it will support the injured worker. And what I mean by this is it should be one of these, it should be all of these things at the same time. It should be achievable, safe, constructive, and productive. What achievable means is when work is achievable, we help to provide confidence to the workers as well as ensuring the work is achievable based on the worker's injury and any limitations. So what we mean by that is, regardless of what the injury is, you should be working with the employee, working with their current restrictions to ensure they're able to achieve whatever tasks you're giving them. If the worker has a broken ankle and you tell them that they have to climb up a ladder, that's an unachievable sort of event for that worker at this time, because they're not able to. They're not able to do that safely. The second thing, safe. We want to continue to keep all our workers safe. So this is a key component when workers are returning or you're modifying work for them. As per my other example, you need to make sure they're not going to injure themselves worse by virtue of whatever modified work you've provided them. It needs to be constructive. So are you able to continue increasing the skill level of your worker? You want to look for work that, although it may be modified, it is contributing to their skill development and helping them return to their full accountabilities prior to injury. You can't just have them counting paper clips. It has to be doing something. It has to be an event, a task, a series of tasks that is constructive. So it can't be outside of that sort of area. And it kind of leads into what productive means. We want to be productive, contribute to the overall success of the company. Consider making the work productive for the worker and rewarding. So constructive and productive kind of dovetail into each other. It basically means you can't have them just sitting in a lunchroom watching Netflix. You could be penalized by the Workers' Compensation Board for having modified work or reporting to the board modified work that is not within these events, within these levels, achievable, safe, constructive, or productive. I'm going to skip this case study. It doesn't really apply. We do have a few people from Alberta on the call today. We'll go quickly through this. These are just some differences between the Ontario system. So everything, I think I've pointed out all the relevant sections that were very specific to Ontario throughout the workers' compensation part. But there's different areas for Alberta. There's the Act, regulation, the code. The Act outlines the duties and obligations of the employees and employers. The employee rights are basically the same, slightly different. The right to know, the right to compensation for workplace injury, and the right to refuse unsafe work. So slightly different than the rights in all the other provinces, but still nonetheless important. Regulation outlines the requirements as relate to government policy and administrative matters, and the code outlines the stipulations and safety rules that fulfill the duties and obligations of the employer and employee. Again, I don't see this as fundamentally different than most other jurisdictions in Ontario, or in Canada rather. It's again, sometimes it's more about the terminology. WCB highlights in Alberta. You got to report within 72 hours to complete and submit. You need to return a work notice given to the WCB within 24 hours. Your return to work program has to gain modified work for your employee. And if the employee is unable to return, WCB may offer return to work services, which include training on the job, academic or technical assessment, job. Again, to me, these are all the same. Every province has varying degrees of this. This is more to do with terminology. The boards will, if the employee is never, you have a truck driver, let's say, and you're supplying them as a temporary employee to a truck driving company, and they have an injury and they can no longer ever do truck driving again. Every compensation board is going to look for other areas that they can do it, and they're going to provide either retraining, they're going to provide job skill matching, maybe transitioning them to a dispatch role, let's say, or sending them to school to learn, computers so they can move to a dispatch role. The board's requirement is to ensure that the employee is returned to safe, meaningful, productive work, even after the injury itself. The benefits, every province terms the benefits slightly different, whether it's loss of earnings, whether it's a temporary total disability, temporary partial disability, non-economic loss payments. Again, terminology, they're all slightly different how they refer to them, but they do refer to the benefits provided to employees while they recover from the injury themselves. I think we've gone through this. Alberta is no different than any other province in terms of returning an employee back to safe work. So there is the onus to provide modified work to the employee that is achievable. Alberta has very specific, they have different names of the reports. Again, this is more terminology. The form CO40 to be filled within 72 hours. The Ontario equivalent would be the form 7, the worker report of injury, the form C060, Worker report of injury in Ontario is Form 6. And then a doctor, in Ontario, it's a Form 8. Here it's a Form CO50. So all these are requirements of employers once there is a workplace injury. And there's just a small distinction between Alberta and Ontario in terms of some of the terminology and timelines. Lastly, we have some links for learners. These are links to the Provincial Compensation Boards of Canada. They are more relevant depending on what province you are. So if you're in Ontario, you're going to want to know your Ontario Provincial Board. However, there are some other benefits to the board, like BC has great training videos. So if you're looking for something specific for, let's say, I don't know, ladder safety, BC has a pretty good program, and they've had a good program for a while for videos and media associated with specific training for workers and for employees and for employers. Resources, the Canadian Centre for Occupational Safety and Health is a good one. It's a government agency. They are a great resource for all sorts of different hazards in the workplace and dealing with specific issues that arise in the workplace. They have safety information. If you're looking for WHMIS, that's the place you want to go. That has probably the best sort of information on WHMIS 2015. Ministry of Labor within your jurisdiction, Alberta Labor. So all of these things are very important to learn. CANLI is another one. If you are involved with any sort of managing workers' compensation or any sort of legislation in your business, employment standards, whatever it may be, CANLI is a great resource. They have all sorts of basically every piece of legislation and statute and regulation in Canada. They keep a very up-to-date database. It's, within a couple of days of the government making changes, it's reflected in CANLI. So another great resource. And then lastly, that's it. If there are any questions, your best bet's probably to get in touch with ACSESS. They'll have a number of resources. If you have a question right now, by all means, put it in the chat. I'll be happy to answer. But get in touch with ACSESS. Get in touch with Jennifer. She'll be able to find you the information, or at least bring you into someone with an ACSESS that has the technical expertise to answer. So anyways, I thank you very much. We went through a lot of information today. I wish you all the best of luck as you write your CPC. But good luck to all, and thank you very much. Take care.